I don't mind 2 minutes. I've looked at your development from darkening to complain about the behavior of the then Minister of Finance, the Prime Minister, Patrick Manning. I sent him on his way. I said, go talk to your minister. Now, the point that I am trying to make, perhaps I'm belaboring the point, is that I would have hoped that your questions and your requests would have improved over time. They have not.
Introduction of bills. The Motor Vehicle and Road Traffic Amendment Bill 2026 in the name of the Minister of Transport and Civil Aviation.
Minister of Transport and Civil Aviation.
Madam Deputy Speaker, in accordance with Standing Order 64-1B, I beg to move that the next stage of the Motor Vehicles and Road Traffic Amendment Bill 2026 be taken later in the proceedings.
Honourable members, the question is that the next stage of the Motor Vehicle and Road Traffic Amendment Bill 2026 be taken later in the proceedings. All in favour say aye. Aye. Any against? I think the ayes have it.
The Law Reform Zones of Special Operations, Special Security and Community Development Measures Bill 2026 in the name of the Attorney General.
Honourable Attorney General.
Honourable members, the question is that the next stage of the law reform
Not from you.
I would love to have yours. Yeah. Madam Deputy Speaker, in accordance with Standing Order 64-1B, I beg to move that the next stage of the law reform, Zones of Special Operations, Special Security and Community Development Measures Bill 2026 be taken later in the proceedings. I'm sorry.
Honourable members, the question is that the next stage of the law reform, Zones of Special Operations, Special Security and Community Development Measures Bill 2026 be taken later in the proceedings. All in favour say aye. Against? The ayes have it.
House of Assembly Amendment Bill 2026 in the name of the Prime Minister.
Honourable Prime Minister.
Deputy Speaker, Deputy Speaker, in accordance with Standard Order 64-1B, I beg to move that the next stage of the Tobago House of Assembly Amendment Bill 2026 be taken later in the proceedings.
Honourable members, the question is that the next stage of the Tobago House of Assembly Amendment Bill 2026 be taken later in the proceedings. Those in favour say aye. Aye. Any against? The ayes have it.
Public Business Government Business Bill, second reading.
Minister of Transport and Civil Aviation.
Madam Deputy Speaker, I beg to move that a bill entitled An Act to Amend the Motor Vehicles and Road Traffic Act 4850 for the introduction and implementation of a fixed penalty warning for specific traffic violations in the 9th schedule and related matters be now read a second time. Madam Deputy Speaker, the bill was drafted under the visionary leadership of the Honourable Prime Minister, Mrs. Kamala Persad-Bissessar, SC, who has demonstrated strong and responsive leadership by not only listening closely to the concerns of motorists, but by moving decisively to implement solutions which are now presented to this Honourable House in the form of this bill. I must also express my gratitude to the Honourable Attorney General and the technical staff at the Attorney General's Office and the Ministry of Transport and Civil Aviation, who have worked diligently to produce the Motor Vehicles and Road Traffic Amendment Bill 2026 before us today. Madam Deputy Speaker, due to the technical nature of the bill, please permit me to refer to my notes. Madam Deputy Speaker, the objective of this bill is the implementation of mandatory fixed penalty warnings for specific traffic violations in the 9th schedule. At present, the existing legislative framework relies heavily on prosecution-based enforcement for a wide range of traffic offences. This approach has placed significant pressure on law enforcement agencies, members of the public, and the courts, often resulting in delays and administrative burdens. Madam Deputy Speaker, this bill seeks to address these challenges through the introduction of a fixed penalty warning system in respect of designated traffic violations. These warnings would allow certain offences to be dealt with administratively without the immediate issuance of a fixed penalty notice, while still maintaining accountability and deterrence. Madam Deputy Speaker, the Motor Vehicle and Road Traffic Amendment Act No. 9 of 2017, Amendment Section 81(1) of the Motor Vehicles and Road Traffic Act, Chapter 4850, states that a constable may issue a fixed penalty notice to a driver who is found to be in violation of the law. This wording confers a measure of discretion on law enforcement, recognizing that traffic enforcement must, at times, be exercised with sound judgment and fairness. However, experience since the enactment of the amendment has shown that the exercise of this discretion can be uneven and inconsistent across Trinidad and Tobago. In the absence of a structured warning framework, two drivers committing the same violation may face different outcomes. If left unregulated, risks undermining public confidence in law enforcement and may give rise to unfairness or discrimination, which are inconsistent with constitutional principles. We have examined the data and note that in 2024 and 2025, a total of 27,554 fixed penalty notices were issued for the 18 specific traffic violations that have been identified for the fixed penalty warning in this amendment. Of that total, 14,887 fixed penalty notices were issued in 2024 and 12,667 were issued in 2025. In addition, there have been 1,414 documented warnings issued during 2024 and 1,091 documented warnings issued in 2025 to motorists in respect to traffic violations. This therefore shows that drivers stopped for the same traffic violations were in some cases given fixed penalty notices, whereas in some cases were given simple warnings. Furthermore, it is recognized that there are circumstances where the immediate issuance of a fixed penalty notice may not always be the most appropriate response. This includes situations where the nature of the violation is such that the driver may not have been immediately aware of the offense, or where the contravention may have occurred shortly before detection by law enforcement. In these circumstances, the absence of a structured and legislated warning system can result in uncertainty in enforcement practices and perceptions of inconsistencies among motorists as highlighted. This issue is important because the exercise of statutory discretion by the authorities must always conform to the fundamental principles of the Constitution, especially the rule of law, equity before the law, and procedural fairness. While Parliament has lawfully conferred discretion on the law enforcement agencies through the use of the words must issue, a fixed penalty notice discretion cannot be exercised in an arbitrary, inconsistent, or unguided manner. Where discretion is applied differently to motorists without clear standards or safeguards, it raises concerns of unequal treatment and undermines the constitutional guarantee that the law be applied fairly and consistently. It is therefore necessary to provide a clear, transparent, and uniform framework. This is where the fixed penalty warning system plays a pivotal role and serves as a solution to balance accountability and fairness. Madam Deputy Speaker, many stakeholders support this amendment to the legislation, including but not limited to the Trinidad and Tobago Police Service and the Licensing Authority. I will now provide a detailed overview of the clauses of the bill to the House. The bill itself comprises 8 clauses, and I also wish to make it clear that this government has not sought to reinvent the wheel with the fixed penalty warning system. In fact, this bill represents tried and tested legislative constructs used in similar circumstances, which I will discuss later on. Clause 1 of the bill provides the short title. Clause 2 provides for the commencement of the Act proclamation by the President. Clause 3 defines the Act used throughout the bill to mean the Motor Vehicles and Road Traffic Act. Clause 4 of the bill amends Section 20B of the Act by inserting the words or the 9th schedule to make it clear that any breach of a condition which is listed in the 9th schedule constitutes a traffic violation. Clause 5 of the bill inserts definitions for business day and fixed penalty warning into Part 6 of the Act. A business day is defined as any day other than a Saturday, Sunday, or public holiday, Carnival Monday, or Carnival Tuesday. A fixed penalty warning means a warning issued under Section 80A of the Act and includes a duplicate of such warning. Clause 6 of the bill inserts a new Section 80A and 80B into the Act. The new Section 80A details the procedures and processes which follow after a constable issues a fixed penalty warning for traffic violations specified in the first column of the 11th schedule. It contains 9 subsections. Subsection 1 provides for a constable to issue a fixed penalty warning to a driver where he has reason to believe that a traffic violation is being or has been committed. Subsection 2 allows a constable to affix a fixed penalty warning for a traffic violation specified in the 11th schedule to any part of a vehicle where the fixed penalty warning may easily be seen. Subsection 3 provides that the owner of the vehicle on which the fixed penalty warning was affixed shall be presumed to be the person liable for the traffic violation mentioned in the fixed penalty warning. Subsections 4 and 5 of Section 80A provide that only the driver, someone under the driver's authority, or the person liable for the traffic violation shall remove the fixed penalty warning that is affixed to a vehicle. A person who contravenes subsection 4 is liable on summary conviction to a fine of $3,000 in accordance with subsection 5. Subsection 6 indicates that when a fixed penalty notice is issued or affixed, the police officer in charge of the station for the relevant district shall send a duplicate of the notice to the licensing authority within 1 day from the date of issue or affixing. Subsection 7 provides that where driver or owner of a vehicle complies with the fixed penalty warning, he shall be provided with a certificate of compliance in the form approved by the minister and published in the Gazette. A copy of the certificate of compliance has to be transmitted to the licensing authority by the police station or such other person as such other location as designated by the minister within 1 day from the date of issue of the certificate, which verifies that the traffic violation was remedied. Subsection 8, thank you. Subsection 8 states, once a certificate of compliance is issued, the driver or owner would be discharged from liability for the traffic violation mentioned in the penalty warning. Subsection 9 indicates that where a fixed penalty warning is not complied with, it shall be deemed to be a fixed penalty notice, and the driver or owner shall be liable for the traffic violation in accordance with the Act. The new subsection 80B details the contents of a fixed penalty warning. It contains 5 subsections. Subsection 1 provides for the contents of a fixed penalty warning and states that it should bear the signature of the constable Subsection 2 provides that a fixed penalty warning shall be in the form approved by the Minister of Transport and Civil Aviation and published in the Gazette. Subsection 3 states that the number of business days in the fixed penalty warning shall be in accordance with the second column of the 11th schedule, and in subsection 4 provides that the person and location in the fixed penalty warning shall be in accordance with the third column of the 11th schedule. Subsection 5 states that the Minister may, by order, subject to negative resolution of Parliament, amend the 11th schedule. The proposed subsection 5 is especially important as it allows the Minister from time to time, by order, to add and remove traffic violations for which the warnings can be issued, adjust the time frame within which defects are to be remedied, and reported for which a fixed penalty warning was issued, as well as add and alter the locations at which violators can present themselves to report and produce evidence that the requirements under the fixed penalty warning has been adhered to. Clause 7 of the bill amends item 36 in the 9th schedule of the Act. Clause 8 of the bill inserts a new 11th schedule which specifies 18 traffic violations listed in the first column of the 9th schedule, for which penalty warnings shall be issued. These violations have been identified as ones of fixed penalty warnings would be appropriate in the first instance, with an opportunity for violators to remedy prior to fixed penalty notices being issued. There are 18 violations. They are: item 35, no identification lights for the illumination of identification marks on vehicles at night, 3 business days. Item 37, number of passengers to be carried not printed on right front door of taxi, 3 business days. Item 39, no tear and MGW painted on vehicles, 3 business days. Item 40, vehicles with defective fittings, 7 business days. Item 41, vehicle without silencers or fitted with cutouts, 3 business days. Item 42, unauthorized lights to front or rear vehicles, 3 business days. Item 43, unauthorized letters and figures on vehicle, 3 business days. Item 44, vehicles without 2 headlamps, 3 business days. Item 45, vehicle without park lights, 3 business days. Item 46, vehicle without taillights, 3 business days. Item 48, no left-hand drive notice affixed to appropriate vehicle, 3 business days. Item 63, vehicle without horn, 3 business days. Item 64, permitting excess sparks, smoke, or visible vapor from vehicle, 7 business days. Item 72, vehicle without reflective mirror, 3 business days. Item 74, use of noisy vehicle, 7 business days. Item 76, use of vehicle with no windshield wiper or defective wiper, 3 business days. Item 79, public service vehicle without spare tire, 3 business days. Item 82, placing of advertisement on side of window of taxi, 3 business days. The 11th schedule also details in the second column and third column, respectively, the time in which the traffic violations are to be remedied and the locations where vehicles are to be presented for inspection as evidence of the violation being remedied. Madam Deputy Speaker, the practical operation of the proposed sections A to A and A to B is designed to be simple, fair, and effective for both motorists and enforcement authorities. Essentially, where constable defined in the Motor Vehicles and Road Traffic Act to include a police officer, transport officer, a traffic warden, and an estate constable employed under the Supplemental Police Act in a public body listed in the 8th schedule, has reason to believe that any traffic violation specified in the proposed 11th schedule is or has been committed, the constable shall issue a fixed penalty warning. In circumstances where the driver is present, the warning may be handed directly to the driver. Where the driver is not present, the warning may be affixed to a visible part of the vehicle, ensuring that the motorist is properly notified of the infraction. Once a fixed penalty warning is issued or affixed, the responsibility for the violation rests with the driver or the registered owner of the vehicle. The warning clearly identifies the nature of the violation, the steps required to remedy it, the time frame within which compliance must occur, and the location at which the driver owner must report and provide evidence that a defect or non-compliance has been remedied. The driver owner is then afforded a reasonable opportunity with either a 3 or 7 business day window based on the violation to repair the defect. After doing so, the driver owner is required to report to any police station, any office of the licensing authority, or another location as specified in the warning, and to produce evidence of compliance within the prescribed period. Upon satisfactory verification, the driver owner will be issued a certificate of compliance. That certificate serves as confirmation that the requirements of the fixed penalty warning have been met and results in the driver or owner being discharged from any further liability in respect to the violation. The matter is thereby resolved without need for a fine, court proceedings, or further enforcement action. However, in the event the driver owner fails to remedy the defect or fails to report within the time frame, the fixed penalty warning automatically converts into a fixed penalty notice. In those circumstances, the driver owner becomes liable to pay the prescribed fine just as if the fixed penalty notice had been issued in the first instance. Madam Deputy Speaker, the Ministry of Transport and Civil Aviation has conducted several stakeholder meetings to put the required infrastructure in place. The amendment bill before the Honourable House is aligned with international best practices. For example, our CARICOM neighbour, St. Lucia, has a system of warnings built into the revised laws of St. Lucia 2023. Under Section 88 of their Motor Vehicles and Road Traffic Act, if an officer believes that a person has committed a tickable offence, a notice stating a breach, and if it's not rectified, the person will be liable to pay a fine, be imprisoned, or the person's license or permit may be cancelled or suspended. While this piece of legislation is not exactly identical to what we are proposing in this amendment bill, the resulting effect is the same. That is, motorists are issued a warning and has time to rectify. In the United States, the opportunity to fix or repair vehicle defects detected on roads by law enforcement agencies prior to the imposition of fines form part of their traffic laws, regulations, and codes in several states. As being proposed in this amendment bill, formal written warnings are also part of the enforcement process for certain traffic violations. Further, there are provisions which require that the correction of defects must be reported to the relevant law enforcement agencies, and where there is a failure to remedy and report, penalties are then imposed. States with similar provisions include New York and Indiana. Moving across to the South Pacific, Madam Deputy Speaker, in Fiji, there are defect orders within its legislative framework. Further to Regulation 1063 of its Land Transport Vehicles Regulation and Construction Regulations 2000, if a police officer, authorized officer, or inspector is of the opinion that a defect or defects do not render the vehicle safe, a defect order can be issued directing that the defect be rectified. Madam Deputy Speaker, South Australia provides a useful example of how a constructed defect notice system can operate in practice. Under Section 145 of the Road Traffic Act 1961 of South Australia, authorized officers have the power to inspect vehicles and issue formal defect notices where vehicles have deficiencies. Where the deficiency does not pose an immediate safety risk, a defect notice may be issued. These notices must clearly state the date of the issue, the officer issuing it, the vehicle concerned, the nature of the defect, and the repairs required. The notice can be issued directly to the driver or, if the vehicle is unattended, affixed to the vehicle, and a copy must be sent to the Register of Motor Vehicles. The vehicle cannot return to normal use until the defect is repaired, inspected, and a clearance certificate issued. In essence, this system requires that defects are formally recorded, repairs are mandatory and verified, the licensing authority is directly involved, and the system is enforceable and accountable. Madam Deputy Speaker, this framework established under Section 145 of South Australian Act is similar to what we are proposing in this amendment bill, a structured, traceable, and enforceable warning system that improves safety, compliance, and accountability. Madam Deputy Speaker, this bill reflects a balanced approach that recognizes not only the importance of road safety, but also ensures that efficiency and fairness in the administration of justice. Warnings will be issued for offences escalating to fines or prosecution. As a result, punishment becomes proportional to risk and severity, not automatic. This therefore encourages a corrective approach rather than a penalty-driven system. There are situations where the defect arises shortly before it is detected, giving the driver little or no opportunity to correct it. A structured warning system allows an enforcement officer to draw the issue to the driver's attention, provide guidance, and allow the driver an opportunity to rectify the breach before action is taken, ensuring enforcement remains fair and reasonable. This system can help build the trust between the motoring public and enforcement agencies. When drivers know that infractions may result in warnings rather than fines, they are more likely to interact positively with law enforcement and adjust further behavior. While there has been a reduction in numbers between 2024 and 2025, over 10,000 violators were recorded in both instances. This means that for 2 years, over 10,000 individuals per year were issued fixed penalty notices and deprived of the opportunity to make the relevant adjustments to their vehicles. For 2026, thus far, the records show that 51 warnings were issued to drivers relating to the 18 traffic violations identified in the amendment bill, and 232 fixed penalty notices were issued. By introducing a fixed penalty warning for the 18 violations, it is expected that there will be a profound decline in the vast number of fixed penalty notices given. Individuals will now be granted the opportunity to rectify any violations brought to their attention by a constable under the Act. This will give individuals a reasonable amount of time to address the issue. Furthermore, Madam Deputy Speaker, the fixed penalty warning system allows the motorist the opportunity for early detection of traffic violations, which would in any event be identified by examiners at inspection stations or the licensing authority. Drivers and registered owners are therefore already expected to have their motor vehicles free from defects, so there is no additional burden being now implemented to have vehicles in good condition on our nation's roads. It is acknowledged that persons may contest fixed penalty notices where they are not aware of the defects with their motor vehicles for which notices were issued. By issuing warnings with an opportunity to fix the defect, there will over time be a reduction on the burden of the magistrate courts, as such matters will be diverted away from the court system. This effectively frees judicial and administrative resources to focus on more serious and dangerous traffic offences. Madam Deputy Speaker, this bill establishes a system that is firm in accountability and sound in administration. While it affords motorists the opportunity to remedy infractions, it clearly provides that this opportunity is not without consequence. Where a motorist fails to remedy the defect or report within the time frame, the fixed penalty warning automatically converts into a fixed penalty notice, and the prescribed fine becomes payable as if the notice had been issued in the first instance. This approach addresses non-compliance and preserves the integrity of the enforcement agencies. Additionally, Madam Deputy Speaker, the bill provides for a clear and efficient administrative framework. For example, the requirement created in proposed Section 80A6 mandates that a duplicate of each fixed penalty warning be transmitted to the licensing authority within 1 day, which ensures accurate record keeping, effective oversight, and reliable tracking of compliance by those in receipt of warnings. This strengthens the coordination between the TTPS and the licensing authority, thereby reducing the risk of errors or abuse. Moreover, the standardization of the form and the content of the fixed penalty warnings as approved by the Minister and published in the Gazette ensures that issuance across Trinidad and Tobago is done in a clear and uniform manner. Importantly, the legislation also incorporates a necessary degree of flexibility by empowering the Minister to update the categories of violations, adjust compliance timeframes, and designate reporting stations which guarantee that the warning system remains responsive, efficient, and relevant as our operational needs evolved. Madam Deputy Speaker, in conclusion, government holds firm to the position that this amendment bill is necessary as it aims at modernizing our local traffic enforcement framework while also strengthening the public confidence in the administration of the law by ensuring that enforcement is fair, consistent, and constitutionally sound. In essence, this bill is a practical response to real and persistent challenge within the traffic enforcement system. It recognizes that not every defect warrants the immediate issuance of a fixed penalty notice. At the same time, it preserves the authority of law enforcement and the deterrent effect of penalties by ensuring that non-compliance has clear consequences, including the conversion of warnings into fixed penalty notices where the required correction is not carried out. This is not experimental legislation. It is grounded in existing regional and international systems like those referred earlier, informed by data and supported by stakeholders. Madam Deputy Speaker, this government recognizes that the success of any legislative reform is determined not merely by its intent, but by its implementation. The fixed penalty warning system will therefore be introduced through a structured and carefully managed implementation process. I therefore commend this bill to the House and urge all honourable members to support its passage. Madam Deputy Speaker, I beg to move.
Thank you, Minister. The time is now 4:17, so we will have a break for tea. This House is now suspended. We will return at 5 minutes past 5.